So, hi everyone. Today's session is Law for Accounting. My name's Shazia Khan, and it's Learning Outcome 4 today. I just want to summarise what we did in the last Learning Outcome, which is Learning Outcome 3, so you've got a better idea of what we did in the last session, and then we'll carry on to Learning Outcome 4. So in the last session, we looked at legal principles, legislation, case law, and ethical codes, and why they're so important for a business or an organisation. We also looked at ethical codes related to businesses and professional organisation. We looked at government guidance codes issued by professional bodies or specific industries. We also looked at the status of law, regulation and guidance and why that was so important. We looked at corporate governance and ethical practice, malpractice, fraud and bribery. We went on to look at elements and consequences of malpractice. We then went on to look at defences against malpractice for professional accountants and elements of consequences of fraud. We went on to look at elements of consequences for bribery and money laundering. We then went on to look at national and international regulations relating to money laundering and looked at what constitutes money laundering. We looked at reporting for professional accountants in relation to money laundering. So what the structure is in regards to money laundering. We also looked at the consequences of failing to meet money laundering regulations. And if there was a breach, what is the penalties for money laundering? 14 years, maximum 14 years and fines. We also looked at the computer misuse and cybercrime, the Computer Misuse and Misuse Act 1990. We looked at offences and penalties under the Computer Misuse Act. So what happens if someone misuses any sort of information via computer? Cybercrime. We looked at cybercrime under the Fraud Act and cybercrime offences and misuse of that. So we looked at different elements. So we looked at 3.1, which was to analyse the relationship between legal principles, legislation, case law, and ethical examples with reference to cases and examples as well. We also looked at 3.2, which was the elements and consequences of malpractice, fraud, and bribery in business organisations, and also gave some examples in regard to that and what that actually meant. We then went to look at 3.3, which was to explain offences and penalties related to money laundering and what the different penalties are and what the different offences are. Embezzlement, fraud, it could be tax evasion. These are some of the offences in regards to money laundering. We also looked at 3.4, which was to explain offences and penalties related to misuse and cybercrime. So this is just a quick overview of what we've done in the last session, which was Learning Outcome 3. Now we're going to go on to Learning Outcome 4, which is to understand areas of law affecting business and professional operations. So Learning Outcome 4, the assessment criteria. We're looking at 4.1, which is to analyse the requirements of data protection legislation. 4.2, explain the intellectual property can be protected. 4.3, assess the impact of legislation relating to employment. 4M1, assess the importance of intellectual property. The indicative content for Learning Outcome 4 is the data protection legislation, so use of information in business, requirements of data protection legislation, Data Protection Act 2018, GDPR, impact of requirements on business, penalties for non-compliance. We also looked at intellectual property law, which is the different types of intellectual property law, protection through copyright, patents and trademarks. We looked at protection of digital assets, remedies for unlawful use of intellectual property, and importance of intellectual property for any businesses. We also looked at employment law, which we're going to expand on. We looked at employed and non-employed status, the legal consequences of employment, key features of employment contracts, termination of employment contracts, unfair, wrongful and constructive dismissal. We're going to look at statutory redundancy, employee obligations, for example, social security and equal opportunities. So firstly, we'll start with what is data protection. So it's a key piece of legislation that commonly used by businesses to protect their data, and any sort of data collections can be protected. And this is so that any elements of fraud is not committed. The requirements of the Data Protection Act are firstly that data protection and 6 important principles: be obtained and processed fairly, lawfully and transparently, be processed for specified, explicit and unlawful purposes, and shall be processed in any manner incompatible with these purposes, be adequate, be accurate and kept up to date, be kept for no longer necessary for the specified period, and by processed in a secure manner, taking appropriate security measures. So these are some elements quickly that we've gone through, and then we're going to go through a little bit more later. So what is intellectual property? It's a key terminology. What is intellectual property? It's something that you create using your mind, for example, a story, invention, artistic work or symbol. What intellectual property is, so your name or your product, your invention, it could be your design, it could be anything, so which we'll go through more in detail. Then we've got what is employment law. So you've got the Data Protection Act and you've got overview of what employment law is. So you know, UK employment law can be complicated. Individuals can be classed as employees, workers or independent contractors. Whilst independent contractors have no employment right, workers are offered of the same protection as employees. So you've got a diagram there that shows the employment and employment law, health and safety issues, anti-discrimination in laws, employment, learning, employment. If you just increase the sign of that diagram, so leaving employment and employment rights. So health and safety can be things like, you know, the health and safety in the equipment in the workplace. Employment rights could be that employers have certain rights if they're leaving. And then leaving rights is there in regards to, you know, employers can only have these if they leave the organization. And then anti-discrimination rights, things like, you know, working time directive or, you know, no discrimination, everyone treated equally. So these are many aspects that are regulated within employment law. Analyze the requirements of data protection. As we mentioned, there's 6 principles, okay? So the 6 principles are in regards to the data protection. So they are consent of data, contractual necessity, legal obligations, vital interests, legal compliance, which we've gone through, processing of data, and legitimate interests. So these are really important when it comes to identifying that. So your personal data, what is defined as your personal data? So the term personal data is the entryway to the application of the General Data Protection Regulations, which is GDPR. Only if a processing data concerns personal data, the General Data Protection Regulations apply. The term is defined in Article 4, subsection 1. Personal data are any information which are related to an identified or identifiable natural person. So it's data related to one individual. You've got data protection. So data protection is about avoiding any sort of harm to individuals by misusing or mismanaging their data. So it's really important that you protect any sort of data, and it's safeguarding the data and restoring important information in the event that the data is either, corrupted or compromised or lost due to things like cyber attacks, shutdowns, intentional harm, or human error. It embraces the technologies, practices, processes, and workflows to ensure rightful access to data, so that data is available when it is needed. So to protect any sort of data, there's several different technologies and techniques, things like, magnetic or solid storage devices. It could be things like, traditional data backups. These can protect individuals' rights. It could be things like storage tiering. So, we look at the importance of data and why it's so important in today's climate, because data protection and privacy challenges, in industry, major issues businesses and their data protection teams almost daily include the maintaining and retaining of, data and collecting it. It's so important. Then you've got the GDPR principles, which are lawfulness, fairness, and transparency, as with data protection. The purpose limitation: only collect for specific purposes and use it for other purposes. It could be data minimization: only collect the data you need for what you are using it for. So don't just get the data. You need to make sure you are using it for the right reasons, and there's, that is protected all the time, because, data needs to be protected as it's, it's confidential information, and the laws apply to GDPR in protecting data. Accuracy, so now as keep it up to date. Storage limitation, don't keep it for too long. Integrity and confidentiality. Accountability, so you are accountable, so make sure information is protected and you are stringent with everything. And accountability, these are really important elements of GDPR principles, in regards to protecting individuals' personal data. GDPR and data protection terminology. So the data controller is the person or organization who determines how and what data is what data processing is. The data processor is the person of an organization who takes an action with the personal data you control. This might be a third party acting on your behalf. Processing is anything done to personal data, including storing it. The data protection officer's specific role, which will have a legal requirement for many organizations, including large church bodies such as NCIs or dioceses. So, there are large organizations that would have impact to that. Can I still process personal data? Do I need consent? GDPR, again, is the main, the GDPR is the main regulator for this. The Data Protection Act 2018 is the UK's implementation of the GDPR. Everyone responsible for using personal data has to follow the strict rules called data protection principles. As we mentioned the principles earlier, they must make sure that the information is used fairly, lawfully, and transparently. For example, you can process personal data without consent where it is for the performance of a contract, for compliance with the legal obligation, to protect the vital interests of data subject or another person, in the exercise of official authority, or in the public interest, for the purposes of legitimate interests you are undertaking. Only if none of the above apply do you need consent. So it's really important to get consent and be careful how you use the the personal data, whether you have the right to access it, whether you have the right to erase it, or whether you have the right to restrict any sort of processing as well. 4.2, explain how intellectual property can be protected. So intellectual property covers any original ideas, designs, discoveries, inventions, and creative work produced by an individual or a group of people. Intellectual property wasn't a big deal in the past, where you had to protect it. However, information is more accessible and easier to distribute in today's society due to technology. So safeguarding your creations and your works from infringers, copycats, and thieves has become vital in any business. Intellectual property not necessarily to ensure that innovations won't be copied or stolen. It establishes an incentive so that whatever you create can proliferate and benefit more people without violating your rights. Types of protection. So you have copyright, which is automatic protection. So copyright applies to the protection of tangible and intangible creative works. And then you have design rights, which are shapes of objects. Then we have trademarks, which are product names, logos, jingles, and the time to allow for application is 4 months. Registered designs, appearance of a product include shape, packaging, patterns, colors, decoration, and the time allocation for that is 1 month. Patents, inventions, and products, example, machines and machine parts, tools, medicines, around 5 years. So, these are the time to allow for application. Copyright, how copyright protects your work. So copyright applies to the protection, as I mentioned, of tangible and intangible creative works. You own the copyright the moment you create something. If you do not register it, however, it will be easier to validate your ownership, especially in a dispute. So if you take your time to register your work, copyright expires 70 years after the death of the creator, but also can be longer depending on the nature of the intellectual property. So, like I said, it protects your stuff automatically. Protection when you create any sort of literary work, any sort of non-literary work, written work, sound, music recordings, films, broadcasting, and you can mark it with that symbol, the C, which says copyright on it. So the Berne Convention for the Protection of Literary and Artistic Work, as amended in September 2020, 1979, 28th of September. Copyright prevents people from copying your work, as we mentioned, distributing copies of your work, whether free of charge or for sale, renting or lending copies of your work. So I can't just give it to anyone. Performing, showing or playing your work in public, making an adaptation of your work and putting it on the internet. And as we mentioned, copyright protection overseas is protected under the Berne Convention. How long can copyright last? As we mentioned, 70 years after the author's death. So that's if it's written, dramatic or musical or artistic work. Sound and music recording, 70 years from when it's first published. In films, 70 years after the death of the director, screenplay, author, and composer. Broadcasters, 50 years from when it's first broadcasted. And layout of published editions of written, dramatic, or musical works, 25 years from when it's first published. So if you have a dispute about licensing, your collective society can contact the copyright tribunal to ask them to decide on some disputes about licensing. So the next one is patenting your invention. You can use a patent. So patents are, the fact that you are able to use elements of, if you've invented a unique product, machine or equipment, or chemical composition, you can also protect your intellectual property by filing for a patent with the USPTO online. The patents carry out legal protection that excludes others from making and distributing your invention unless you have given them the license. So it's really important you register it. There are different types of patent processes, and the conditions or requirements depend on the product or invention. So you'll have to look at that, identify which applies to you carefully. What cannot be protected? So what cannot patent certain types of inventions? Things like literary, dramatic, music, or artistic works. A way of doing business, playing a game, or thinking. A method of medical treatment or diagnosis. A discovery, scientific theory, or mathematical method. The way information is presented. Some computer programs or mobile apps. Essentially biologically processed like crossbreeding plants and plant or animal varieties. So these cannot patent. There are different types of patenting processes, like I mentioned, which you need to look into carefully before patenting your document. Most intellectual property patents are valid from 15 to 20 years after the filing day. After this lapse, your product will have a patent pending status unless you renew it with USPTO. Protection of digital assets. Taking protection a step further by trademarking your company's logo or registering online content for copyright protection. Any processes your company uniquely creates can be patented. Protecting it via digital assets. So digital assets is a digital entity owned by an individual or a company. Example include digital photos, videos, and songs. These are assets are not tangible, meaning they're no physical presence. Instead, they are files that reside on storage device, such as a local computer or a cloud-based network. So these are protected through internet sources, so it's through, like, as we mentioned, digital assets can be protected through storage devices. Digital assets can now be worth millions of dollars. The fact alone should be a reminder that digital assets can be used just as valuable physical assets and should be protected accordingly. So, there is an element of that. Digital assets can also be lost due to lawsuits, creditors, and divorce. However, there are several tool strategies that can place a level on strong protection around cryptocurrency and other digital assets, such as a domestic asset protection trust and an offshore asset protection fund. Cryptocurrency, so these are forms of digital assets. Cryptocurrency and other digital assets, volatile and vulnerable as they are increasingly mainstream part of the financial investment market and require the same level of protection as other financial and physical assets. Employing the right strategy and tools can ensure your assets are protected from any sort of legal action. Remedies for remedies for unlawful use of intellectual property. So intellectual property gives you a certain exclusive rights to your intellectual property. Where someone infringes on these certain exclusive rights, certain remedies become available to the owner of intellectual property. So remedies available can be things like injunction, an award of costs, damages on or of the account, it could be tracing orders, it could be orders for publication. So these are some of the damages that are available for a successful claimant. Three kinds of remedies against infringement of copyright, namely civil remedies, which is injunction, damages or account of profit, delivery of infringing, copying and damages, which are injunctions is the most common remedy for intellectual property rights infringements. Injunctions are orders that require named individuals to refrain from doing certain specific acts. So in this case, it would be using the intellectual property right owners' intellectual properties. Damages or account profits where a profit has been made as a result of the intellectual property right infringement. The IPR owner may be entitled to compensation. And then you've got award of costs, and that could be an award of costs is a court order stating that one party is to pay the other party the costs incurred in issuing legal proceedings. And delivery or destruction of infringing items. This is while there's an automatic entitlement to the delivery or destruction of infringing items or materials and items used to make such infringing items, the courts may make such an order where infringement is shown. And tracing orders can be things like the courts may also make tracing orders which order the infringing party to provide information on where they acquired the infringing items. This is generally used where the infringing party did not create the infringing items themselves. So there are remedies available for criminal and for administrative remedies as well. Some relevant questions: why should I protect my intellectual property? Many of these things can be protected under intellectual property rights, have essential roles to play in the success of your business. Strong brands are often crucial to retaining loyal clients. If your brand is easily copied, then its strength is diluted and you may lose customers. Likewise, a good invention is often profitable because it solves problems in a way other inventions do not. It's easily copied, then other businesses can eliminate your competitive advantage. Carrying out an intellectual property audit. You must carry out an intellectual property audit before you can pursue your intellectual property protection. So it's really important. You need to bear that in mind. Next slide is importance of intellectual property on businesses. So it's in businesses, it's really important because, it looks at the potential of the business. So, a well-crafted intellectual property strategy can help maximize the potential of your business using and understanding intellectual property, things like, securing competitive advantages, reducing tax liability, general revenue streams, serve as a source of intelligence, facilitate access to financing, attract investors and partners, and avoid to mitigate relevant risks. So, if you look at some benefits of intellectual property rights for a business, a brand sets out a business apart from its competitors, building a trust and consumer loyalty, and that would be trademarks, protecting your concepts and ideas. For reassuring investors to increasing margins using your patent strategically can improve your bottom line. Protecting the way your product looks with an industrial design can provide a major competitive advantage. Copyright protects the expression of idea in different forms. So when the source and authenticity matter, using geographical indications can identify your product as being the real deal. Trade secrets have potential to protect a wide range of information and has commercial value due to its confidential nature. So these are some of the advantages of benefits of intellectual property on a business. So importance of intellectual property for businesses, again, looking at some of the importance of intellectual property for businesses, why it's so important in regards to it. And it's not intellectual property rights are valuable assets for any business. Possible among most important it possesses. You know, intellectual property rights are important because they can set your business apart from competitors. They can be sold or licensed, providing an important revenue stream, offer customers something new and different, and form an essential part of your marketing brand, and can be used for security of loans. So it's really important for a business to have intellectual property rights, because it gives them protection. And it makes a business successful, and it protects any sort of protects any and reap the benefits from the work from long term. So it is there to protect you as a business as well. And within a smaller business, intellectual property plays a big part because it's there to ensure any sort of strategies that are adopted through securing your intellectual property. It also copyright original works and protecting your rights overseas as well in different territories. Now we're going to look at 4.3 is to look at assessing the impact relating to employment. So employment law regulates the relationship between employers and employee, and it governs what employers can expect from employees, what employers ask employees to do, and employees' rights at work. So, it covers a whole array of things, in employment laws. So recruitment, training, employment offer, discrimination, health and safety, parental rights, whether you like whistleblowing, employment tribunals, redundancies, employment and the law. So within employment law, this diagram we looked at earlier as well, so you've got a little bit of an idea. So you've got employment and the law. So you've got things on health and safety legislation, employment rights, anti-discrimination, leave employment, leaving employment. So employment legislation covers different statutes or acts that set out legal entitlements employees have to certain conduct, benefits and rights from their employer of their employment. Anyone working within HR will be trained in employment legislation and how it relates to all aspects of work. It's part of what they refer to as civil rather than criminal law. Criminal law covers issues between the state and a wrongdoer, whereas civil law deals with issues between two parties, and in this case, between the employer and the employee. The employment relationship is governed by a variety of different statutes and acts that are regarded as employment law. And it gets updated all the time every year because there are minor to major changes that have been made to employment law. So types of employment, you've got, there are two types: employee works under a contract of service, and self-employed independent contractor works under contract for services. The Employment Act, Employment Rights Act, 1996. This is an act that governs a majority of employment relationships, including but not limited to entitles around things like contract of employment, pay, dismissal and grievance, time off, pensions, studying and training, maternity, paternity and flexible working hours, termination of employment. You have the Equal Pay Act, which is in regards to, does not only deal with pay, but other terms, holiday and sick pay, and it applies to the equality clause of the opposite sex. You've got the Working Time Directive 1998, as amended by the regulations 2007. And this stems from a European Union directive on working time and are enforced by the Health and Safety Executive and fall under the health and safety legislation. The legislation sets out some key requirements around maximum number of hours a person can work, limits on night work, health assessments, time off, and rest breaks and annual leave. So this is what they look at. National minimum wage. So as we've looked at them at the national minimum wage from 1998, the national minimum wage, let's have a look at what the national minimum wage are now. So in April 2022, the national minimum wage for 18 to 20 is £8.60. It's increased by £1.11. And for 16 to 17-year-olds, it's £6.40, increased by £1.12. And for apprentice, £6.40. So there's been an increase of £1.12. So it's quite a large increase. Anyone over the age of 21, it's gone to £11.44. So, you know, it's quite a big increase in regards to that. So that was from April 2024. So that's more recent, you know, in regards to what they are allowed. So this is literally by law, your employer must pay you this amount. If they don't, then they are breaching the conditions. Statutory redundancy. So you'll normally be entitled to statutory redundancy if your employee and you've been working there for the current employer for 2 years or more. So you would be entitled to get that statutory redundancy. In the UK, the amount at the moment of April 2023 is capped at number of years of 20 years is £643 a week. And that is capped in regards to your statutory redundancy pay. And it's capped at 20 years and your weekly pay is average you earned per week. And, you know, there's a calculator there that you could calculate your redundancy pay. Termination of employment contracts and dismissal generally. Termination actually, employers with a period continuous of employment at least 1 month, but not exceeding 2 years, are entitled to at least 1 week's notice from the employer. Those with 2 years continuous employment or more are entitled to 1 week's notice for each complete year and up to a maximum of 12 weeks notice. So these are some of the elements. So as we mentioned, continuous employment period of notice, 1 month to 2 years is 1 week, 2 years to 12 years, 1 week per complete year, and 12 years plus 12 weeks, 12 weeks notice. So you're not entitled to statutory redundancy pay if you fall in one or more of the following categories: former registered dock workers, Crown servants, members of the armed forces or police services, apprentices who are not employees at the end of their training, and a domestic servant who is not member of the employee's immediate family. Then you've got short-term and temporary layoffs. You know, these are, a layoff is if you're off work at least 1 working day. Short-time working is when your hours are cut. So you can claim statutory redundancy if you are eligible and you've been temporarily laid off for either more than 4 weeks in a row or more than 6 non-consecutive weeks in a 13-week period. You should write to your employer telling them you intended to claim statutory redundancy pay, and this must be done within 4 weeks of your last non-working day in the 4 or 6 period. If the employer does not reject your claim within 7 days of receiving it, write to your employer again, giving them notice, and your claim could be rejected if your normal work is likely to start within 4 weeks and continue for at least 13 weeks. Consultation. You're entitled to a consultation with your employer if you're being made redundant, and this involves speaking to them why you've been made redundant, any sort of alternatives for redundancy, and if your employer is making up to 19 redundancies, there are no rules about how they carry out the consultation. So, the less length of the consultation is will start at least 30 days before any dismissals take effect. And for 100 or more redundancy, the consultation starts at least 45 days before dismissal takes effect. So unfair, wrongful and constructive dismissal is constructive dismissal is one of them, that this is where you feel forced to quit your job to do your work conditions become intolerable. Another is wrongful dismissal, where you are dismissed in breach of terms of your contract, for example, when you are not given the notice period you are entitled to. So, there are elements of that, and an employer, you would need to refer to ATHE to help you for that, and there would be an employment tribunal. There would be a case that would be gone to the employment tribunal on the basis that you've been wrongfully dismissed or unfairly dismissed. The Advisory Conciliation Arbitration Code of Practice. The ACAS Code of Practice is a set of standards that are expected in the workplace by employers and employees. The code includes the following code of practice on disclosure of information to trade unions for collective bargaining purposes, code of practice on the settlement agreement. So, they work with, the ACAS work with millions of people around to help them and support them in regards to any forms of unfair dismissal, or, and there are codes of practices that you must follow, things like code of practice on disclosure of information, as I mentioned, code of practice on settlement agreement, amend the code of practice to flexible working agreements, code of practice on time off for trade union duties, and code of practice on disciplinary agreements. So, employers and employees should act consistently within the codes of practice. They should inform, investigate, and put their cases forward, and they should be accompanied for the if there's any sort of formal disciplinary or not. Unfair dismissal. Every employer who has a qualifying period of employment has the right to not be subject to an unfair dismissal. If there's to be a dismissal, an employer must show the reason. Falls in one of the categories set out in the Employment Rights Act. There's 5 categories, so that the first one is that the employer lacked capability of or qualification. Second one, the dismissal was a result of the conduct of the employee. So things like poor attendance, failure to follow instruction. Third one is there was genuine redundancy. Fourth one, the continuation of employment will contravene a statute. For example, you need to drive in your employment, but you are being banned due to speeding. And the fifth one is some other substantial reason. This would be dismissal, which does not fall within any of the above reasons. Some examples are where you have a personality clash with your employer, or where there's non-renewal of your fixed-term contract as maternity leave. Unless employer can prove one or more of the above 5 reasons for dismissal, then the termination of employment would be deemed to be unfair. Constructive dismissal is, on the other hand, is where you are forced to resign in response to your employer's conduct, which has made your position untenable. Although it's referred to as dismissal, in practical, it means resignation. So the term constructive dismissal, constructive unfair dismissal, is you feel forced to resign, as I've mentioned. It's difficult, very difficult to prove such cases in court because employment tribunals believe that it's only in extreme circumstances that someone feels forced to leave their employment. A classical extreme example is not being paid for your wages or being physically assaulted. There are many permutations of what constitute constructive dismissal, but they involve having your work life made so difficult by your employer or by your colleagues that you feel you have no option but to leave. So a few examples that you may resign in this situation: working conditions, pay-related, employment status, behavior by the employers. So, they are the minimum employment period required so that you can claim constructive dismissal is 2 years continuous employment. Equal opportunities. What is equal opportunities in regards to employment? So what is equal? It came into force in 2011, and the primary objective is to encourage the identification of discrimination, victimization, and sexual harassment, and further to eliminate them all. The term equal opportunities oppose the idea that all workers in an organization should be entitled to and have access to all of the organization's facilities at every stage of employment, including the pre-employment phase. This means that every individual should have an equal chance to apply and to be selected for post pre-employment. They should have an equal chance to be trained and promoted while employed with the organization. They should have an equal chance to have their employment terminated equally and fairly. Denying any employee or prospective employee their right to equal opportunity in the workplace is tantamount to discrimination, which is considered unlawful under the Equality Act 2010. The Equality Act 2010 specified 9 areas that are termed in the legislation as protected characteristics. These include things like age, sex, race, disability, pregnancy, marital status, sexual orientation, gender reassignment, and religious background. Discriminating against workers because of the 9 characteristics is against the law. So for employees to comply with the terms of Equality Act, employees must have policies in place and must adhere to certain practices that aim to prevent accident claims, discrimination, and foster equal opportunities within the organisation. All workers and job applicants must be treated equally and be given the same set of opportunities regardless of their age, sex, race, disability, sexual orientation, disability, culture, or anything personal characteristic that may be discriminated against. As a worker, you have the right to a fair practice and behaviour in the workplace, fair allocations of workloads, equal access to benefits and conditions as other employees, a workplace that is free from unlawful discrimination such as harassment or bullying at work, competitive merit-based selection processes for recruitment and promotion, and fair processes to deal with work-related complaints. All employers must follow certain procedures in the workplace, as we mentioned, to ensure that workers are treated appropriately and fairly, and that things are being equal, so no candidate is treated unfairly because of the protected characteristics. And every employer should have their own equal opportunities policies in place, as mentioned, which is customized to their organization. The policy must detail the steps an organization would take to comply with equality legislation and promote equality in the workplace. Having a formal policy makes it easier for employees to know what is acceptable and expected of them as individuals, as part of the organisation. So it's really important as an organisation, be it large, small, medium, that you have policies in place for equal opportunities, so that there are no breaches of equal opportunity, or then no cases go forward in regards to any sort of breaches of employment breaches that would expect you to go to an employment tribunal. When an organisation supports the principle of equal opportunities for all, employees can rest assured that they're not discriminated against in the workplace. Employees are committed to working hard when they know they have equal opportunities for advancement and there are no barriers for job progression. So these are some of the resources we've used for the elements that we've gone through. So things like equal opportunities, we've gone through health and safety laws, we've gone through data protection, we've gone through elements of data protection and intellectual property. So these are the resources we've used for them. And also further reading is on Moodle that you could refer to. There's some links there that you can refer to. And if you have any questions, learner work at ukvarsity.co.uk. Submission of the assignment to be done on learner work at ukvarsity.co.uk. And its submission is 2 weeks after the completion of the unit and its delivery. So now we've completed learning outcome 1, 2, 3, and 4. The next the next session we'll have is the assignment discussion session. So these are some backup slides that you can look at in regards to today's session, which is learning outcome 4. So we've got the ACAS Code of Practice, which looks at the elements of raise and deal with issues promptly, act consistently, carry out necessary investigations, give evidence and opportunity to put their case forward, may be accompanied by a formal hearing, the right to appeal. Then we've got the disciplinary process, so investigatory meeting, investigate fully and collect evidence. There's no disciplinary action at investigatory meeting. The suspension must be paid and as short a time as possible. They try to make it short as possible because they want to make sure that they are dealing with everything consistently. Disciplinary, so inform, ideally 3 days written notice. You give full details, including copies of evidence. A safe dismissal is possible and the right to be accompanied. So this is some additional resources for you to have a look at, okay? Which I'll go through quite quickly. The rights to be accompanied. So you have a fellow worker. You could be accompanied by a fellow worker, or you could be accompanied by a union rep or a minute taker. So, you know, in some instances, if you are part of the union, take advantage of that. Take a union rep with you and identify any sort of issues around that. So the meeting. So your review of your evidence. So they prepare advance in question in a confidential room, no interruptions, remind of right to be accompanied and stay calm, adjourn before making a decision. Workers have the right to have a statutory right to be accompanied by a companion, where disciplinary meeting could result in things like a formal warning, taking some of the disciplinary actions, or the confirmation of a warning. So, you know, discipline, decision-making, secret recordings, reasonable sanctions, you state the reason, improvement expected, set a time for review. So if you fail to improve, remains current, so the right of appeal. The gross misconduct, so immediate dismissal for first offence. Follow a fair disciplinary process. There's no notice. Notice will be due. The appeal process, so can appeal against any disciplinary action. Insist appeals are made in writing by time. Limit mirrors disciplinary process. The manager not previously been involved, and you inform of the outcome ASAP, and there's no further right of appeal. In grievances, you have to establish the facts. Notice of a formal hearing. You should have the right to be accompanied, as we mentioned. The decision after the meeting, inform them accordingly, and the right to appeal. recommended actions, again, ACAS, really important. Look at all the disciplinary procedures and grievances, and they are able to help you as well. Dignity and responsibility. So keep dignity front of mind. Take responsibility for ensuring dignity. Clarity, ensuring you have understood, ensure you understand, so the rapport. Responsibility. So if your responsibility is ensure the employee understand what is happening and has a positive experience during the meeting, regardless of the outcome. The grievance meeting is not a confrontation. It's extremely difficult to predict how the employee will react. Even if the employee has openly expressed a desire to leave the company or talked openly about how little this situation bothers them, he or she may find the reality of the meeting quite distressing. You may find the employee's emotional reaction surprising and distressing. So this is a diagram in regards to an employee or independent contractor, the tests that would be used, the distinction, formation of a contract, so implied terms, duties of employer, duties of employer, statutory provisions, Employment and Rights Act, Employment Act 2002, termination of a contract, you have wrongful dismissal, definition and remedies, unfair dismissal, permitted reasons, inadmissible reasons and remedies, and redundancy, the definition and compensation. So this looks at the HR planner, and it looks at the context of a range of laws that protect individuals and groups and whose main aim is to ensure employees are treated fairly. These cover the whole of the employee relationship, from sourcing staff to parting from them. And with things like fairness in recruitment and selection, so the HR planner has to consider a number of equity issues in the recruitment and selection process. Unlawful discrimination, so it's unlawful to discriminate in the recruitment process, and the terms or conditions are offered on the grounds of things like sex, including pregnancy and maternity, marital status, including civil partnership status, gender reassignment, so you can't discriminate in a job on gender reassignment, sexual orientation, race, national origins, ethnics, nationality, includes citizenship, disability, religion or belief or lack of religion or belief, age, trade union membership or non-trade union membership, and status as fixed term or part. So you cannot, in recruiting someone, you cannot be unfairly discriminating on them grounds. Basis of discrimination, so you've got direct discrimination, you've got treating people less favorably on the grounds of their sex, race, on their age, disability. Indirect discrimination, applying on apparently general rule which is practiced one sex or race, harassment, violating someone's dignity, and victimization. Fairness and protection during employment. So an employer has a number of rights throughout their term of employment and what they need to be aware of. Things like it's unlawful to discriminate on grounds listed in the previous slides. Under the Health and Safety Act, the employer has a duty of care towards employees and anyone else who may be affected by their business and activities. Under the Data Protection Act, which we looked at earlier, employer must comply with the 8 principles to protect personal information. Under the Information Consultation Employees ICA regulations, employers with 50 or more employees must provide written statements which specify the main terms and conditions of employment, itemized by pay statements, health and safety regulations, and economic situation within their employment prospects. Family-friendly law. So family-friendly law falls with a number of categories, such as maternity rights, adoption rights, parental leave, paternal leave, and pay, right to request flexible working. Maternity rights is quite important in regards to an employer must provide the legislation and must follow the legislation. Things as reasonable paid time off for antenatal, protection from discrimination on grounds of pregnancy, the right to statutory maternity leave for 52 weeks, the right to statutory maternity pay, which is SMP, for 39 weeks. Adoption rights, so anyone adopting a child has the following entitlements: so protection from discrimination on grounds of adoption, the right to statutory adoption leave for 52 weeks, the right to statutory adoption pay for 39 weeks, parental leave, so either parent has unpaid parental leave if they have been employed by the same company for a year or more, are an employee with a contract of employment, are a parent named on the child's birth certificate. Foster parents have the following adoption leaves as well. The employer can take a total of 13 weeks parental leave for each of their child up until the 5th birthday. That's foster parents. If the child is adopted, they can take a total of 13 weeks parental leave until the 5th anniversary of their placement or until their 18th birthday, whichever comes first. Paternity leave, again, a male employee can take statutory paternity leave up to 2 weeks if an employee with a contract of employment, if they are the biological father of the child of the mother's husband or the partner, have been their employer at least 26 weeks by the end of the 15th week, or will be fully involved in the child's upbringing. Emergency leave, employees have the right to unpaid time off if they need to deal with emergencies. The right to request flexible working hours, which is a big increase in the employment law, and it's still changing all the time. Provided you are an employee and have worked for the employer for 26 weeks continuously, you have statutory right to request flexible working hours. Leaving the organisation, as an employee may have leave employment of their own accord or dismissed with or without notice, which means the contract of employment is terminated. An unfair dismissal is when an employee is dismissed and the employer doesn't have a valid reason for the dismissal or acted unnecessary. So dismissal can be on the grounds of misconduct, capability, redundancy, retirement, or legal restriction, or some other substantial reason. So I've gone through the additional slides with you for Learning Outcome 4, which you can read more in detail. I've just quickly gone through. We've finished Learning Outcome 4 now on Law of Accounting unit, and if you have any questions, please refer to email us at learnerwork@ukvarsity.co.uk. Some further reading for you to do on there. Submission of the assignment to be done on learnerwork@ukvarsity.co.uk, and it's 2 weeks of completion of the unit and its delivery. So the next session we will be doing next week is the assignment discussion session. So there's a lot for you to read around here. There's additional reading on Moodle, so have a read around that before we go through the assignment discussion session next week. Thank you for attending today's session, and I will see you in the next session. Thanks.